Dear friends, the Legal Literary Club of MMBA has started its function to deliver lectures on March of Law. I have been chosen, or rather I have been given the privilege to deliver this address on behalf of the MMBA Legal Literacy Club on the March of Law. I took up several decisions during this month. One of the citations which was much impressed is the judgment which was delivered by the Apex Court in 2022 Live Law Supreme Court, page 678. Messrs. Partil Automation Private Limited and others versus Rageja Engineers Private Limited. The subject is mainly on rejection of plaint. You, that is the practitioners who are practicing on the civil side, are very well aware of rejection of plaint. It is being ordered under Order 7, Rule 11, CPC. Rejection of plaint is to be ordered on 5 grounds as per the CPC. The first one is where it does not disclose a cause of action. Number 2 is where the relief claim is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. And number 3 is where the relief claimed is properly valued but the plaintiff is returned upon paper insufficiently stamped and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. And number 4 is where the suit appears from the statement in the plaint to be barred by any law. And the next one is where it is not filed, that is where it denotes the plaint, where it is not filed in duplicate. And the F is where the plaintiff fails to comply with the provisions of Rule 9. These are the grounds that has been mentioned, and several cases have arisen on these grounds, and especially on the ground of where it does not disclose a cause of action and where it is the suit is barred by any of the rules of law. This is that is A and D has been repeatedly come to the acid test of the several high courts and the Apex Court, and several judgments have been delivered. But here is a case wherein under the March of Law, even though a ground has not been mentioned in Order 7, Rule 11D, one another ground is being newly delivered by the Apex Court, that is the Commercial Courts Act has recently come into operation. You all very well know. The Commercial Courts Act, an amendment has come by which, that is in the year 2018, by which section 12A has been newly introduced. Now the effect of the said 12A is a pre-institution mediation and settlement has to be initiated before a suit is being filed before the commercial court. Suppose the relief asked is not an urgent relief. There is no urgent relief is necessary, and the suit is being instituted before the commercial court without pre-institution mediation and settlement. The Apex Court says that the plaint has to be rejected. This is the new ground which has not been mentioned in the CPC. It is a judgment made law under Article 141 of the Constitution of India. So this ground is a new ground where the lawyers practice in commercial courts or commercial division bench, wherever it is being practiced. The question that arises is a pre-institution mediation and settlement process has to be initiated and a conclusion has to be arrived at, and thereafter only the suit can be instituted. Suppose this pre-institution mediation and settlement process has not been adopted, what is the effect? It says the plaintiff is liable to be rejected. Now, in this judgment, several discussions have been discussed. One is when the plaintiff has to be rejected. Number two, the other proposition which has been laid down is the plaint can be rejected suo motu. There is no question of any application is being filed by any of the parties. Any of the parties means the defendant has to file it. But even before the defendant appears, the court says the plaint can be rejected suo motu by the court itself. That is, what is the stage at which the plaint can be rejected? You all very know that the plaint can be rejected at any point of time. But here is a case wherein the plaint is being rejected suo motu by the court. Now, what is the stage? That stage, especially the court says, before the summons is being issued by the court of law under Order 5. Now, Order 5, Rule 1 says, when a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement. So, Order 5, Rule 1 says, as soon as the plaint is instituted. Now, the next question arises wherein a distinction has been made also. What is the difference between presentation and the institution? The presentation of a plaint is not a complete process, because the presentation of the plaint may have several defects in the plaint, and the court may ask the party who has filed the suit to correct those mistakes and thereafter represent it. Then only the process of institution arises. Now, what is the effect of presentation of the plaint? The effect of the presentation of the plaint will arrest the running of the time contemplated under the Limitation Act. Now, what is the institution of the plaint? The institution of the plaint is the plaint which has been duly presented with all the directions that is necessary, that is as per Order 4, Rule 1 and 2 read together, it will say it is a duly instituted plaint. The duly instituted plaint means all the documents which are necessary, all the court fee which are necessary, and all other things have been duly complied with before filing the plaint, and after verifying of the plaint, the suit will be instituted in a competent court. So that is the question of institution. Now then only the question arises, when the plaint had been duly instituted, the court can suo motu see whether the legal necessity of pre-institution mediation and settlement process had taken place. Now, regarding section 12A, the section is very important for understanding the facts behind this case. That is a suit, I am reading just section 12A, a suit which does not contemplate any urgent interim relief under this act shall not be instituted. That is the word that it takes into consideration. The Apex Court takes into consideration a suit which does not contemplate any urgent relief under this act shall not be instituted. That means, before issuing the summons by the court to the defendant, the section 12A says the necessary conditions which are contemplated under section 12A has to be complied with. Namely, the first one is the suit is of such a nature that no urgent relief is necessary or needed. So if you go through the plaint and if you see that no urgent relief is necessary, then the plaint cannot be instituted unless the pre-institution mediation and settlement process has been complied with. That is the law that has been laid down by the Apex Court. Now, one another aspect that has also to be taken into consideration is whether this particular judgment is retrospective in operation or it is prospective in operation. This judgment says that it is in prospective operation, it is not in retrospective operation, because even though this section 12A has come into force on 3/5/2018, now we are in 2022. nearly 4 years has passed. In the meantime, several litigations have come to an end wherein the interim relief has not been sought for, the plaint ought to have been taken on file, and disposal may also ought to have been done. This question will arise provided they are pending before the court of law. Now, one another aspect may also be taken into consideration, that is, when I read over the judgment, for relying upon this proposition, they exactly take into consideration two sections, namely Section 80 CPC and Section 69 of the Indian Partnership Act. You all very well know that while instituting the suit against the government, Section 80 notice has to be given provided there is no urgent relief is necessary. Suppose any urgent relief is necessary, then we file a petition seeking permission of the court to dispense with the Section 80 CPC notice. Then thereafter the matter has been taken on file, and when it is discussed and if it is found that there is no urgent relief is necessary and the want of suit notice is mandatory as far as that particular suit is concerned, then the plaint has to be rejected. In the same manner, before institution of the suit, a firm has to be registered under Section 69 of the Indian Partnership Act, and if the firm has not been registered, then also the same fate. This matters has been taken into consideration very elaborately in the above said judgment. So as far as the said judgment in the live law is concerned, it takes into consideration what is meant by filing, what is meant by institution, at what stage the plaint can be rejected. Moreover, to apply this, the doctrine of prospective overruling, it also takes into consideration Article 141 of the Constitution of India, and it takes into consideration of the earlier judgment of the Golaknath case, wherein the doctrine of prospective operation has been considered. And apart from that, it has also delivered that the plaint has to be rejected. It is a mandatory in nature. So now a new ground has arisen for rejection of the plaint by the court suo moto, even without an application, because the apex court says there is no word that any of the parties has to file a petition for rejection of the plaint in all the grounds. When that is so, even for this ground also, the court itself can suo moto reject the plaint on the basis of non-invoking or non-observance of the precondition, namely free institution, mediation and settlement. For relying upon the position that the court can suo moto reject the plaint, it also relies upon an earlier judgment, that is 2018 SAR Civil Supplement, page 806. That is a case that comes under the Representation of People Act, wherein a full bench judgment has been, a division bench judgment has been delivered in Madhiraja Venkata Ramana Raja versus Bediragiri Ramachandra Reddy and others, wherein the apex court has held the court can suo moto reject the plaint, but that proposition has been very elaborately discussed by their lordships of the apex court, namely their lordship Justice Joseph and Rishikesh Roy, where they have judged the plaint can be rejected on the sole ground of non-observance of pre-institution mediation and settlement under the Commercial Courts Act. Thank you for giving the opportunity by the MMBA to offer this small lecture on the march of law, especially in the CPC regarding rejection of plaint. Thank you.